something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. Tonight we're going to talk about those questions, basic questions in the criminal justice system in Harris County, Texas, which is Houston, Texas. That's the main city in Harris County. We're going to have just a conversation about basic terminology, basic terms. I have my two regular co-hosts with me, Danny Sneed and Damion. Oh Lord, he's dressed up because this is the last show of the year. He got on his red, for Christmas. And then we have Damion Walker. Damion's here. We got to make him feel good. He just lost his wallet, and people are always trying to use his credit cards. But that's Houston. We live in a very dangerous, mean city. So all we can do is try to hope for the best. And luckily, he didn't get hurt in that transaction. But I want to talk about a few things. Our director, Mark, will be putting them on the screen as we look at them. But the first thing I want to talk about in terminology is the criminal complaint. So, Mark, if you can try to show the criminal complaint, I just want to jump right into talking about it. And I know you said you cut it up into different pieces. Yeah, can you see that?
I see felony charged murder. That's what stands out to me already.
Okay.
What the charge is.
Okay. All right, so you see, that's the indictment. So see if you see one marked that says complaint. I wrote it in red, just like that part that says indictment, but it says complaint.
Okay.
All right, so that's a complaint. And basically what a complaint is, that's in Harris County. So I've blacked out the people's personal information, but that's what it looks like. And do you see to the mid-right where it says, Mark, I can't see because it says standby. Can you take that off so I can read it? Yeah. Do you see that part where right above to the right of complaint, it says court? Can you read that? Can anybody read that? Because, I got old eyes.
Bail.
Court ordered bail.
To be set at, yeah.
Yep, to be set. And do you see, look above that. Do you see where it says to be? Right above that.
You're talking about the arrest date?
The
To
arrest
be as
date,
good reason to believe.
No.
Not that
Damion
part?
got it. To be. We're going to let the young eyes look at it.
Okay.
Damien's a youngster at the table. Arrest to be.
Yeah.
So what to be means is the police officer did not see the crime. Someone reported this crime to the police officers, and when they came to the scene, they took all of the information to create a police report. You can keep that up. They took all the information to make a police report, but they did not have the person in front of them. So that means the charges, so they called in to the district attorney's office to accept charges. The complaint was created, and the arrest means to be arrested. That's what to be is, the initials for to be. So that's like if somebody stole your wallet tonight, and we find out who did it. Yeah. So say if the store has a video, and you tell the police, the store goes and sees the video, and the store owner, the person working says, oh yeah, I know who that is. That's Charles Brown that did that. He comes in here all the time. Then you can file that police report, and then to arrest Charles Brown, they would issue a to be warrant. So that means to be arrested because he didn't get arrested at the scene. Now, if someone stole your wallet and you caught them as soon as they were stealing it and you held them for the police, it would not say to be right there. It would actually say arrested today's date.
Yeah. So we might to be this guy, right? Like the one that stole my wallet.
The one that stole my wallet.
Stole my wallet about 15 years ago.
But you gotta know who did it. That's the issue. You gotta know who did it.
So my question is, I see why it's significant, but to be, is that something that automatically pops up, or does the officer or who? Now this is a report, right?
No, that is the actual
That's the
complaint. That's an
warrant.
actual document called a
Okay.
complaint
Good, the
that
complaint.
every district attorney's office in the state of Texas uses.
So from the complaint, it goes to the warrant?
That's part of the warrant.
Okay.
That's part of what makes the warrant.
Okay.
Let's go back to the form.
Okay.
And we might have to do this show again because I didn't bring the actual forms with me. Maybe if we could get them printed or whatever, I could look at them, but I didn't bring the actual forms with me where I could see it, so I can't really see. But anyway, but I want to go through that. When you see right underneath that, when you said before where it said court to determine the bail.
Yes.
So that tells everybody that the court is the judge. When you hear the term the court is the judge. So that means the judge will determine bond. Why is that significant in our county with a lot of the information that's going around? Damion, why do you think that's significant?
Because of the bail reform, right? A lot of the bail reform issues, and a lot of people are concerned about who sets the bail and why people are getting out on so many bails too. I think that's one of the issues that you're referring to.
I just want to know what your thoughts are.
Okay.
And Danny, tell me what your thoughts are on seeing that the court sets the bail. What are your thoughts when you see that? And I'm sorry I don't have the documents to pass out.
That's fine.
I had them on my desk and ran off. And
I just know
forgot.
it was a big move to reform bail reform.
Okay. Well, that has nothing to do with bail reform. That form has always looked like that. It just means that the court sets the bail. So the thing that's going around is that the DAs set the bail. That's what you hear all the time, every day. But the document is showing you who sets the bail. You can't set a bail on someone that's not in custody.
Can you
Remember?
influence? Can the DI office?
Let's not go there right this moment. Hold that question. Because I want to educate about the form.
Yes, yes.
Okay, okay.
We want to talk about what a complaint form is. A complaint shows the probable cause of the incident that happened. So, Mark, if you could show us that complaint a little bit more. One more time. Okay. So basically, in the authority in the state of Texas, that's telling what the charges are. I can't read it. I can't see that far, but if you can see it, that's basically saying what happened, and that's a probable cause statement. I don't know if you can go down a little bit, Mark, and show that the probable.
That's the bottom.
Okay, that's the bottom. Well, can you go to the part that's up a little bit higher? All right, just below that last line, it would be saying it's the probable cause statement. So that's the charges, but it also, like right there, do you see where it says probable cause?
Yes, yes.
All right, where it says probable cause. So that's what. So the police officer, when they took the report, they also are typing up something called the DIMS. It stands as DIMES. It's the District Attorney's Management System. They type up the probable cause statement. This is why they believe that this person committed this crime, and that's what's there. If you can read it, you can read it. I can't see it good enough to read it,
I see it.
but can you read it?
Yeah, somebody got shot.
What a part, so blank is a certified peace officer presently employed with the Houston Police Department.
He's a affiant,
Affiant has reason to believe.
and the
and does-
affiant is the police officer.
Oh, the affiant is a police. Okay. Affiant has reason to believe and does believe that on December 2nd, 2023, in Harris County, Texas, blank did commit felony offense of aggravated assault.
Right, and an aggravated assault could be somebody got shot, somebody shot and lived, or somebody could have pointed a gun at somebody, or they could have beat them bad with some physical object and caused serious bodily injury. Let's go back to that. You think you keep reading it? Can you see it good enough to keep reading it? Because I can't see it at all.
Okay. On December 2nd, 2023, at 10:43 hours, at 10:43, affiant was dispatched to blank Houston, Harris County, Texas,
And that was the address.
a Memorial Hermann Hospital in reference to a hospital check shooting. Upon arrival, affiant met with blank. Hereafter, the complainant, who affiant found to be credible and reliable.
And that's going to be an all probable cause statement. So the person you take statements from needs to be a credible and reliable person. Basically, you believe they're telling the truth by the way they, tell the story.
So let me ask this, because it's saying credible and reliable. Does that help the officer's statement, saying that he does believe that this person's, now when they're going to court, they're saying they're going to court. I know it's going a little bit of
Yeah,
before. Just say they're going to court, and then that person has to be found not credible and not reliable, like from the other side? Is that like an issue? Because those are strong words.
Those are strong words, and that's a really good point for you to make, Damion. Probable cause is a police officer saying, I believe it's more probable than not that this happened. And all cases, felony cases, that's a felony, has to be indicted by a grand jury. That's 12 citizens within 90 days of the charge, okay? So, 90 days of the person being arrested. They haven't been arrested yet, but we still try to do 90 days anyway. So, it's only what he believes is credible and reliable for the probable cause statement to get an indictment. It's not for trial. When trial comes out, the police officer can only testify to what someone told him happened, if it's relevant, but he cannot pass judgment. Like, he can't say, well, I believe the person. In trial, that's not possible. You can't do that in trial, because now the person who, the trier of fact, is the jury to decide whether somebody's credible. But on this part, the beginning part, to get it started, what's credible and reliable has to be that whatever the person is saying, the complainant. So the officer is talking to the person that got shot. So he sees they shot, and somebody did it. There's no evidence that they shot themselves. So that's why he believes it's credible and reliable.
Okay.
So it's a lower burden than the burden of proof required beyond a reasonable doubt to convict somebody. Because the officer is just saying that somebody did it, and this person is saying that they know who did it.
It's like the first step of saying
It's
that.
the first step to get charges.
Okay.
It's like he believes, because remember, the title of that little part you're reading, and you can go back to that, Mark, said probable cause. And probable cause means we believe it's more likely than not that it happened, like probably. This is probably true. But I'm not the trier of fact. I'm not the jury. I'm not the grand jury. Things can change. And that's why things a lot of times change from what you hear on the news to what actually happens later. Because this is just the beginning. He's talking to this person. If they start talking to other people, things might change. So keep reading.
Go back down, Mark. Okay. Wait, no. So upon the complainant stated she was at blank here after the witness apartment on the morning of December 2nd, 2023, when she received a text message from the defendant regarding a male they both are dating. The complainant stated she and the defendant began to argue via text messages until the defendant text pull up in parentheses. That's serious right there.
That's it. That's them fighting words.
That's the fighting words.
That
Pull
want
up
the
in
smoke.
parentheses.
So this is a cat fight. This is a cat fight.
No. You say pull up. Well,
No, but I'm just saying, but it's
On
two
the
girls. I mean,
yeah, they texting, fighting.
they're talking about they both dating the same guy,
Yeah, they
right?
text fighting first.
Well, somebody shot him. They like that dude.
Yeah,
Go
that
ahead.
is very, very serious. Okay, so let's go back to that. Look at me on now. So let me get back to pull up.
See it?
Yeah, let me get back. Pull up. The complainant and the witness got into the vehicle and drove to blank Harris County, Texas. The complainant stated when they arrived, she exited her vehicle and the defendant met her while armed with a handgun. The complainant stated the witness remained in the front passenger seat of her vehicle and recorded the incident. Complainant stated she and the defendant engaged in a verbal argument loudly while the defendant pointed the firearm in her direction multiple times. The complainant stated she returned to the driver's seat of her vehicle and placed her hands on the steering wheel. The complainant stated the defendant ran to the passenger side of the vehicle where the witness was sitting and shot the firearm into her vehicle. My goodness. Striking her in the left hand, causing her pain, I'm sure. The complainant stated she drove away from the location and then stopped to allow the witness to drive her to the hospital. She shot her in the hand.
So he took a car to a gunfight.
A car.
So even when she just pulled the gun, that's an aggravated assault.
Yes.
But it's different degrees of aggravated assault. One of the reasons why when there's a charge, it can be from 5 to 99. You know, there's a range. So if somebody pulls a gun, you might just want 5 years probation or whatever. But if they actually pull it and shoot you, you might want a whole bunch of time on somebody. So that's why there's a range to depend on the severity of the crime and if they have a prior record.
But what I see there is that there's a lot of evidence with the text message, with the recording,
There's a
and
recording.
with the shooting. I mean,
Right.
the shooting. Yeah. So
now
there's
you
a lot
see
of
why
evidence.
the officer who's investigated this case says
Yeah.
that he believes she's reliable and credible because he's corroborated what she said looking at a video and looking at the text messages. So life has changed because when y'all got in trouble, it was just what people said. Now there's always video, recording,
Receipts.
text messages,
Yeah.
as people are saying now, receipts. But since this
Receipts,
is an
yeah.
educational show, you can use the slang and I will use the official words, which there is actually evidence to corroborate it. So that's why the officer believes it's credible and reliable. Do you think something like this is probably going to be indicted by 12 citizens that listen to this that are grand jurors?
Absolutely.
Yeah,
Yes.
without doubt.
So their question is to either no bill, which means they don't believe it probably happened, it sounds like a lie, or a true bill. A true bill, once they hit true bill, that creates the indictment.
All my bills was true.
Oh, yours bills was true.
I ain't never had a false
But I
bill.
want to show one more part of the complaint. Do you have the bottom part of it, Mark? I know you said you captured it in two ways. So there should be a stamp at the bottom that shows that that document was stamped in the district clerk's office, basically, where you look for it. All right, thank you. Yeah, that one. So you see that file stamp right there? So what date was it stamped?
November 2nd, 2023.
Okay, so that's when it was filed.
November 23rd.
Was it November 23rd? Because it
November
seems like a lot of those dates you were reading were in December.
Yeah. That
So
was
it's a
always-
month later.
Yeah, go back
a
to
month
that
before?
document.
That wouldn't jive.
Yeah, that might be the wrong.
Yeah, that one said.
Yeah, that you looking at the indictment. Yeah, that's the wrong document. So I think that it was still. Did you
'Cause it
have the
happened
bottom of the
December the
complaint?
2nd.
Yeah, he's looking at the wrong document. That on the complaint was there. Did you have the bottom of the complaint? Okay, so you might.
That's it.
Okay, that's all you have. Okay, perfect. That's okay. So that's a different document. All right, so there's that. So now, Mark, I want you to show the. I called it state's motion for magistrate's order of protection. So now, what the prosecutors will do is file that document. You see what it says? State's motion for.
Magistrate's order for emergency protection.
And a magistrate is what, Danny? A magistrate is a judge. So
Absolutely.
that's different terms for a judge. It can be called the court. That's a judge when you hear the court. Magistrate, that's a judge. And then judge is called judge or presiding judge. So the state now will ask for, because the police officer will ask the complainant, we don't call them victims in criminal law, they're called the complainant, will ask the complainant, do you want a protective order? And so you can get a protective order if there's some kind of intimate relationship or, there's some intimacy wrapped around this situation. For 61 days is the emergency protective order.
What does that include? I mean, because that's just a document.
That's
It don't
just a-
mean to see. No, you don't have an officer outside your door.
Right. But it means that if the person is caught within 500 feet or 1,000 feet, depending on how it was drafted and what the judge signs. Let's go back to that document.
There's not a restraining order?
No, we don't use that term.
Oh, okay.
Is that the bottom of that document? Because I know I gave you two different ones. Can you read some of those terms?
Where? Starting where?
In the middle where those little dots are.
Oh, committing an assault on the protected individual.
Okay, go ahead and read the paragraph before it's just 2 lines.
Wherefore, the welfare and protection of the protected individual, the state respectfully moves this court to grant the state's motion for magistrate's order for emergency protection and order the defendant from committing an assault on the protected individual, committing an act in furtherance of offense under section 42.072 of the Texas Penal Code involving the protected individual, communicating directly with the protected individual in a threatening or harassing manner.
Let's stop there.
Okay.
So communicating could be,
Facebook.
that could be text messages, it could be Facebook. Keep going, Mark, we want to go back to it.
Communicating a threat through any person to the protected individual.
Through a person, so that could be through Facebook or calling a relative or calling that boyfriend that they both share.
Have them talk and say something to.
Right.
And you have to prove all these things. That's the thing.
Yeah, but everybody tapes it now, baby. Because like, how did they first hook up? By texting.
Yeah.
So they're not going. They don't know each other than to text each
He
other.
probably jumped in the DM. What they say? He probably.
That's what I'm saying. But these people now will bring you those DMs. They'll
Yeah.
bring you those
It was
DMs.
going down in the
yeah,
DM.
yeah. As soon as somebody does it, like on Facebook or something now, people save it. Their lawyers tell them to save it. The defense lawyer. So like if this complainant reaches back out to this defendant again and say, you did this to me, but I'm going to get you back, the defense lawyer is going to tell the defendant, if she calls you, you take a picture of it right away. Because, people delete their text messages.
yeah.
They'll delete their DMs.
Vanishing and stuff.
And so they'll make sure that they take copies of it.
That's crazy.
Okay, go ahead. Keep going.
Possession of a firearm. Possessing a firearm unless the person is a peace officer as defined by Section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Going to going to or near the residence of a protected individual, specifically within 200 feet of a
So
residence.
it's 200 feet. That's what I wanted to get. I didn't get that.
Okay.
And it should also say about their employment and things like that. So that's what the prosecutors do that are working at intake. And our DA intake is 24 hours a day. So the cop could have filed that at 2 in the morning, 2 in the afternoon, 3. The DA's office is round the clock.
It never closes.
Parts of it never close. The part that deal with the police, it's called police intake, that never closes. So, but that's just so the judge can see that whenever the person is arrested, it's a part of the file. So the next part, document number 3, will not be that document. It'll be the one marked that's labeled final order, magistrate's final order. Can you read that title?
Magistrates.
He's trying to pull it up.
I think you had it a while ago.
It's similar. It's just where it's the document that the judge signs. Not that one. Sorry. Two of them have similar names. You had it right. Go back
Yeah.
to the title. So one of them is not that one. We're not on that one. All right. Well, that's the one. Okay. So one is the order. Was the request, the state's motion for the order, and then the other one is the magistrate's order of protection. And then that's when the judge actually signs off on it. But it's 2 different documents. So that one is the one that when they find the defendant, they'll have the defendant sign it. Whenever they arrest them, that document will already be filed.
They have them sign the indictment. The
magistrate's order.
magistrate's order. Okay.
Yeah. So the state's just filed it and saying, whenever this person is arrested, I want you to, judge, I want you to go over this with them. And so then the judge has a separate document that's an order. That was a request, a state's motion for magistrate's order of protection. It was requesting it. What a motion means in law is I'm asking the court to do something. So I move the court to do this. Okay?
Is that it?
And then the judge then has an order that they sign, but they have the defendant sign and get a copy of it too. But this defendant hadn't been arrested yet. So this is,
in this case?
no, it was a 2B, wasn't it? Wasn't that the one that was a 2B? It was a 2B. So the statutory warnings or something, once someone is arrested and brought before the judge, sometimes the magistrates, they call them the TV judges when you see them right there. That's what they're going over, these statutory warnings.
Is there a sense of urgency, or is just officers get assigned to do things and they do it in a list of order when they say they have an arrest warrant?
Well, the police
for it to
officers
be-
can always change their procedures, but generally there's a area that executes warrants. So they have a warrant division. So those are the ones that's going out. That's the sheriff's department, that's Houston Police Department, that's all the police agencies. Some of them don't have enough people to do that. Some people just wait until they get arrested with a traffic ticket.
Okay.
And go to jail. People can get arrested on traffic and say, oh shoot, they got a warrant. That's what the cops are going back checking to see if you have a warrant.
So it's a prioritized.
That one's going to be a priority because somebody got shot. So that one, so the officer that takes the report and went to the hospital to talk to the complainant, that officer is going to then turn it over. The day shift people are the supervisors or the experienced detectives. So then it gets turned over to a detective who will work that program. That's a violent crime where somebody got shot, so that will be a priority.
So the DA's office has detectives too, like investigators? Or are you talking about
I'm talking about the police department.
Police, okay.
So let's keep it separate. A lot of people think that the DA investigates. The DA does not investigate.
Okay.
We can't be the DA can't be the lawyers and the investigators. Because remember, whoever investigates the case, if there's a trial, a defendant has the constitutional right to confront their accuser. So that police officer that said that person was reliable and credible, that I wiped out the name, that officer is going to have to take the stand and I swear to tell the truth, the whole truth, and nothing but the truth in a trial. And then the prosecutor is going to be asking questions to get the information out. Prosecutors are not witnesses. It's nothing prosecutors are saying. In fact, juries are instructed in a real trial that you can't take what the prosecutor is saying as evidence. The prosecutor can ask questions to elicit the evidence. But the evidence is coming from the witness stand. You see what I'm saying? So so the prosecutors can't go out and investigate a case because then the prosecutor would be the person on the witness stand.
I see what you're saying, yeah.
But most people don't realize that. People get heartless mad at the DA's office. They call because this officer didn't investigate it right or they didn't file charges. And they say, we want you to investigate it. But people don't understand our roles are different. That's like asking the judge to go investigate. That's not the judge's role. That's not the prosecutor's role.
Is this the same thing?
It's only the police officer's role to arrest people.
Like, so in one of the biggest high-profile cases we had, when Mark Furman was the investigating officer against OJ,
right?
The big deal was to discredit him in his investigation process.
Right.
Not only based on what he did, but in his character and things he did in previous cases, which really led to, I believe, OJ being not found guilty.
Well,
one of the reasons.
When people take the witness stand, officer, whomever it is, their character is in evidence. So the defense has an opportunity, or the other side, whoever puts the person on the stand, the other side has an opportunity to discredit them with witnesses.
And that's why it goes back to that statement too: reliable and credible.
Right, and the officer will say, "This is what the person told me," but the officer can't. It's inappropriate for the prosecutor to elicit whether you believed them or not. Whether they believe, it's no more about what you believe. What you believe was for probable cause. We're through with that stage. Okay. Now it goes to the grand jury. The grand jury might not believe it because maybe the defense attorney, maybe if this person hires a lawyer and can write out their side of the story, or maybe they got some video to where the girl might have tried to hit her and she shot her back, or pulled a gun on her and she pulled one back. Things change. And so, or maybe they did it somewhere where there was video. So the defendant, the reason why you're supposed to get a bond is to go out to find evidence to defend yourself. And so, that's really the original purpose of a bond. So the government can take your liberty, but you have a right to go and try to find witnesses to testify on your behalf and to prove that you're innocent. That's what you're really supposed to be doing. Of course, in today's society, if you get a bond, you're going to go back to work. But you're supposed to also be trying to work on your innocence.
Work your case, yeah.
So work on your case. And so you can then present evidence to the prosecutor to take to the grand jury. You got the cop side, but now this is our side. A lot of defendants don't do that, and defense attorneys don't do that. But if you have a client that's truly innocent, a good defense attorney is going to start at the grand jury stage. So it's usually something written because a defense attorney can't go in there, but they will present both sides.
Okay, so my question is, and cut me off, but you talked about like the evidence and investigating. So is that part of like the discovery phase? I learned that while working at the public defender's office.
That's part of the discovery phase. Okay. That's part of the discovery phase. So that police officer was supposed to get that tape from that girl. He might not have got it there because she got shot. So she might even have her purse with her. Her family might have come to the scene, to the hospital, and taken all her belongings. So at some point, that officer has to follow up, or the detective that they give it to. Because remember, the street officers do the background and they go back on the street. And so then it goes to the detectives to actually follow up because, the assault division, the domestic violence division, the robbery division, the homicide division, all these arson division, all those different people are working in the daytime. They're the experienced cops that are now of the rank of detective.
So they can collect evidence. They
collect all the evidence. And so they're going to go back to her and ask for that tape. And if they don't, every time you go to court, then the defense is going to want it. The defense can't advise their client without having the evidence that the police officer wrote down in this probable cause statement, right? So what is the defense going to want? What would you want if somebody's against you? You're going to want to see this tape to make sure it's true. Yeah. Hear the tape. You're going to want to see the text messages. You're going to see if she might just get a text messages that day. They might have been texting for the last month.
Yeah.
You know what I'm saying? So you don't know what happened. So you got to, as a defense attorney, I would have to find out what happened.
How easy is it for you all to be able to get that information? Because you got a detective going to get it. Do they get it to you as immediately, or do they have to
No,
do their
because they
checks
might
and
have
balances?
500 cases they're working on.
Okay.
And so a lot of the cases are reset and reset and reset because the prosecutor doesn't have it because the cop didn't give it to him. So that's part of what prosecutors are doing all the time. Even though they're in court all day, then at night they're trying to chase down evidence. Because that could happen at 2 in the morning. That could happen at 5 in the afternoon. And the officer's not there. So yeah, that becomes part of the discovery that the defense wants. They want any evidence. For them, it's just going to be those text messages and the recording and maybe the 911 call. The 911 call is usually relevant. But here, even though there's a body-worn camera, this is not a case where the officer saw anything. They might just want, if the officer interviewed the person, while the complainant, while the body-worn camera is on, then the defense is going to want to know that because they're going to want to match up their stories. But this is a case that's a little bit different because only defense that the defendant has in this case is that it was self-defense. So they would have to prove self-defense.
That they, or to say, like you said, they had a gun too.
Right.
And
Now
they came to where I was is a good defense. Like
it's only good if it makes sense. If there's text messages say that they were meeting up, it depends on who was saying let's meet up.
Pull up, yeah.
See, that's the thing. Who was saying what? If the one that said pull up, I'm coming up at you, and she's the one that did the shooting, then it's gonna be pretty obvious who the aggressor
Almost like
was.
she was trying to trap her. Like, come on over
Right.
here, let me get this, let me get you.
Right, right.
Yeah.
And women talk a lot about when they dating the same man. Women get together, get them stories straight, and one of them gonna quit him. You know, that happens without violence. I mean, when I was a young woman, I had women call me about
Come
the
on
guy
now.
I thought was my boyfriend.
Come on, baby.
And found out it was hers and hers. It wasn't just my boyfriend, it was her. But those were old landline phones back in those days. That's the 80s.
Yeah.
It was landlines, but I was in my 20s. And so I'm just saying.
Daddy remember those days?
So we've always had those days, but I never had nobody tell me to pull up because we didn't have cell phones, so you had to call somebody from a landline or a payphone.
Yeah.
So you're not gonna really be close to one another, And men didn't have cell phones like these girls now are going through these men's cell phones. And sometimes
That's ridiculous.
And sometimes these sorry men are letting the women pay their cell bill, so that means they have access to it.
Yeah, no, that don't make any sense.
Yep. So let me tell you this: that ain't the world I lived in. The world I lived in, a girl would have to look in his manual phone book and see my phone number. Back then, men used to put a star by the ones that they like, right?
Rolodex or
Or
something.
use your highlighter.
Yeah. So they might have a heart by it or something like that. So she see that, then you're gonna get a phone call. But back in the day, women got phone calls, and we had old-fashioned answer machines. So they would leave messages on the stupid answer machines about whatever they wanted you to know, and then you got to play it for the man, and then it's like it's on and popping then.
You know about that stuff, Vivian?
Baby, I've been there now. I was cute when I was young. Anyway, yep. I might have taken a few people's boyfriends every now and then. But anyway, or else I thought they were my boyfriends until she called me. But anyway, so a lot of crimes now are about people getting caught, especially during COVID. That's why the intimate partner murder and assault rate was real high, because people who used to go their separate ways during the day, live-in marital people, they were trapped there together. So men are in cells or drive around their cars. They couldn't play with their girlfriends anymore. So then the girlfriends will get restless. They calling them. Women are finding them. Oh, the domestic violence rate went way up, and it was generally because people were stuck at home. And so their outside interests that they just did from 8 to 5.
So all the sneaky links inside
Out the door.
side chicks just they couldn't do
Like
it.
what you just read is real common.
Yeah.
What you read, other than the fact that they met and shot each other. Usually they
Fight.
or they plot. Most of the fights are the two women talk as women, and then the woman that lives with him goes and confronts him. And it's usually between the intimate partners. The man and the woman have the fight.
I heard a statistic in Houston. In one part of Houston, 40% of murders were domestic violence, but Houston as a whole, it was like 35% or 37%. That percentage of the murders in Houston were from domestic violence situations.
So when you hear that the murder rate went down from COVID, it was the domestic partner murders went down because they went up. So they went up. It's about the same amount of violent crime, just criminals, robbing people, shooting people. That kind of stuff is about the same, and it's very high right now. But what spiked us in 20 and 21 was the domestic violence, the domestic partner violence, because people were
That's
together
great
more.
insight, yeah.
I mean, because I'm here, I was there. I mean, I'm at the DA's office, so I saw the cases. And now people are back traveling, going in sales.
Sneaky leaks back on.
Sneaky leaks back on, baby.
Okay.
They're on and popping now. They can go and sneak.
I don't know nothing about that, Danny.
They can sneak back. So
Side chicks are trending again.
Yeah. Side relation. Dudes too.
Everybody. Girls are sneaky too. These women, y'all taught these young girls how to be bad. They're not good girls like us. They just as fast as
And I
y'all
don't
are.
want to believe that women cheat. I really don't want to believe that.
That's because I'm sitting next to two men who don't cheat. But
Exactly.
so if y'all don't cheat, y'all got women that don't cheat. But let's get back to the education part of tonight's show. Okay, let's get back to the edumacation. So I think that we're finished with this because this is just a magistrate's order of protection. And then we were looking at the statutory warnings. Now we want to look at the indictment. That was the first document that you put up there. Take your time.
You working Mark tonight, boy.
Yeah, we
You
working
gotta
Mark
work
tonight.
on the
I
boards
know it.
tonight.
I know
You're
it.
doing a good job, Mark.
We might try this one more time, and then I'll make copies for everybody so we can see it. Mark's trying
Our
to make it
producer
big.
is
Yeah, so you see
working hard on-
the indictment is there, and so, okay, look, come on. I need you to read. Come on,
where?
Damion, read.
What
So I want you to read. You see where it says indictment to the right. Now this one is not a 2B anymore, so I want you to look in those same areas. This one, it should be where the bail is, where the court order bail. You
Bail
see
to
that?
be set at magistration,
Okay.
prior cause, number blank.
Oh, this is another 2B.
Yeah.
All right, this is another 2B. All right, so and these are the actual charges. If Mark goes down, you're not going to see that probable cause statement. Well, no, you'll see it on this one too.
And this is a felony
What is this case?
a murder charge.
Oh, this is a murder case. All right.
It says indictment.
Yeah, this is
Not a
this is an
complaint.
indictment. So there has been a complaint, and now it's being indicted. And remember, we try to indict them within 90 days because that's what the Texas Constitution says. And if you're in custody, say you get arrested when it happens, and your bond is really, really high, and the state does not indict you within 90 days, that's when they have to give you a PR bond.
No matter what kind of case it is.
I can't say that, but it has to be you have to make a bond you can make because there's something wrong with the evidence if you can't be indicted in 90 days. So generally, a PR bond or a lower bond. Say if you got a $50,000 bond, it might get lowered to $5,000. It doesn't have to be PR.
So
But it has to be
so
something
you could
can
be
make.
held in custody for 90 days without being indicted.
Without being indicted. And
Wow.
in small counties, when I was a defense attorney, that would happen a lot. I would get hired by a prior client. Grandmother's, upset because, in Houston, you get a bond right away. But, if you're in a little country town in Texas, and remember, Texas has 254 counties, Harris County just being one of them, one of the 254. You go to one of these little small counties, they might have a judge that's on a circuit that goes between 3 or 4 counties. They might go to this county this day, this county the next day, and so they don't have criminal dockets every day. So
Oh, okay. I see
yeah,
what
in
you're saying.
small counties, they might go to Jefferson. I'm just giving an example.
Okay, yeah.
They might go to Ozark County one day because they might have a population of, 100,000 people. Well, we got 4.8 million people. So they might go there, and they don't have as much crime. And so then they might go to Jasper County, Gonzales County. They might have a judge that has to go around the circuits, but the radius is probably still just, 100 miles, 150 miles, or something like that. So they can't get grand juries together that often either to actually look at the case. So I've had one where I went down on the 90th day, and I was going to get him out, and they actually dismissed it. They didn't even take it to the grand jury. They actually dismissed it. So I got paid, and then we got to drive my client on home. But they dismissed it. But we had done a lot of preparation work, during that 90
Y'all
days.
prepared for, like, going to trial and stuff?
Well, prepared for talking to the prosecutor to show that he didn't do what they thought he did because he was passing through. But I was lucky on that case because the young man's grandmother had just won the
Lottery?
She had just won at the casino,
Oh.
so she had some money. Yeah, so he had been a poor client. I had represented court appointed, and then I was like, how can you afford this? Oh, my grandmother just won, and won where her name is up there. Won a whole bunch of money, maybe $100,000. Now I wasn't doing them like that, but
And you wasn't charging them the whole 100,000.
maybe 10,000.
Okay.
Yeah, maybe something like that. No.
Plus mileage.
Yeah. So we got him out. I didn't have to do nearly as much as I thought, but that's what that happened. So an indictment is where citizens, and this process has changed over the last 15 years. So most of my legal career, the judges would pick people to be on a grand jury. And that's when the cliche came up, you can indict a ham sandwich. Remember when you hear that in Houston? That's because a conservative judge found 12 of their conservative friends, mostly retirees, that had time to serve for 3 months, because grand jurors in Harris County serve for 3 months, about 3 days a week for 3 months. But that got changed. I can't remember what year, but it got changed in the last 10 or 15 years.
And what was the change?
The change is that when everybody gets called for jury service, they just pick them out of that. They just pick them out of that. They pick 12 out of that.
For the grand to do a, for
Be
grand.
on the grand jury for 3 months.
So you can't manipulate it.
So it's not manipulated anymore. So just like you get called to be on a regular jury, you can be on a grand jury.
How long ago did that change in Harris
I
County?
can't remember. Now, if we do a segment like this again, I'll look it up and tell you. But
That was big. That was huge.
yeah,
Because the game was rigged before that.
Yeah, it was right when Black Lives Matter happened. So that was
recent.
Trayvon. Well, it was with Trayvon, because when they used to have Black Lives Matter, I used to go speak and educate the young people. I know this young man named Darrell locally used to be real involved in that. I think right after.
2018.
Oh no, like that.
14,
It was about
15.
10 years ago.
Yeah.
It was about 10 years ago. But anyway, when that happened, regular people come. It's harder to keep them because they have regular jobs, so your job has to cooperate with you. But they work until like from 8 in the morning to like 12, 12:30, 3 days a week. But when it gets to a grand jury, this is what I want you to know, it's 12 of them, but 9 have to agree to indict you. All 12 don't have to. So that's one of the times it does not have to be unanimous.
So if 3 vote against and the 9 vote, then that's
Indicted.
a vote. Okay.
Or if 9 vote no bill and 3 vote true bill,
Okay.
then the 9 win.
And if it splits,
If it splits, then
they go pick another jury.
no. They have to decide. I mean, they know their job is to decide, so they're gonna either decide or not decide.
And you can be brought back in front of the grand jury multiple
The grand jurors
times.
can ask for more information. The grand jurors can issue subpoenas. The grand jury has powers to continue the investigation and say, this is not enough. We'd like to see this before we can make a decision. And then they'll tell that to the prosecutor. The prosecutor has to go tell the police officer that.
So
They can reset it, basically.
how was the grand jury educated? Because these are regular citizens who don't always do this. And then, let's go ahead and answer that one.
There's a presentation given to them by
Okay.
the district attorney's office, the judges. They you read them what the Constitution requires them to do. The grand jurors, they have to pick a foreman in that group that will stamp their name on all of the indictments. But they're educated.
Okay.
They're shown films. They go through like a 3-day educational process
Okay. And that's really good for
to let them know what
citizens.
what their expectations are.
Yeah, because justice is kind of like most times it's like a fast process until it gets to the point where you're trying to prove guilt or innocence. Seems like you get arrested, you go through, you get booked in, you make bail. All of that is usually like a fast process until you get to court and you're actually trying to figure out, okay, guilt, innocence, sentencing, and everything else. But that first, like, I guess, like the facilitation into the system is pretty like quick. Seems
Right.
Yeah.
And that first 90 days, so if you're in jail and you can't get out or make bond, the sheriff in Harris County will then give you a copy of your indictment. If you're out on bond, the lawyer gets it and the lawyer has to give it to you. But not everything's online, so you can print it. With the Harris County District Clerk's Office is the keeper of records. So everybody gets their records from the Harris County District Clerk. Everything is stamped with the District Clerk seal on it, because they're the official keeper of records. So the indictment is giving you notice of what you're charged with, what the mens rea is, which is intentionally and knowingly, and then the manner and means. If you murdered someone, the DA has to put in there using a shotgun that is a deadly weapon, or a knife, or a tire tool that's capable of serious bodily injury or death. So the defendant and the defense lawyer has to have notice of what they did and how they did it. And that's what that indictment paragraph says.
You know what I witnessed and I recall the most when I had my brief encounter with the criminal justice system is when you get on the other side and you're in a room with 15, 20 people that are facing charges, how no one understands the criminal justice system except someone, what we call a jailhouse lawyer, that has been in trouble so many times that he can walk you through the preliminary parts. Well, man, this is what's going to happen. You're going to get an attorney. It's going to take you about 3 months. And they'll be pretty spot on.
Right.
Like, you're going to see this. And you should, I just remember how attentive people were to that information because it's not coming from anywhere else. Like, how long is it going for?
Because sometimes your lawyer not going to see you.
Well, you know, when you first get arrested, it's real now. And the thing about it is, you don't know what you're facing, and so you relying on a jailhouse lawyer to give you information on what do I expect now.
Well, let me tell you one of my frustrations, and the reason why I created this show is, although I know they don't know, they act like they know. And everybody in their family acts like they know. So you might get appointed, and then you got to talk to 15 people in that family, which you're not getting paid to do, that's pissed off if you don't call back when you're in court all day, and they want to tell you about the criminal justice system. And it's all wrong. It's all wrong. I heard this. They might be talking about something in the federal court. It might be something that they heard about in Colorado. It might be all kind of crazy stuff, and everybody knows everything, and they don't know anything about the criminal justice system. Other than, do you understand what I'm saying? It's very frustrating, and that's why I wanted to spend this time on our last show of the year to talk about some of these documents and what they are and what they mean, because even though you've done 15 years, you've done 17 years, you really don't know what those documents are. Now, one of the other things we can do is go through some of the juvenile documents, because they're different, and what a certification is, because you were certified as a juvenile.
Yes.
And there are documents with that. It's a little harder to get those documents because juvenile records are not public.
I even tried to get my when I took my picture in juvenile, and it doesn't even exist.
They don't.
It's so long.
They don't want to scar kids. That's a part of because actually when you're in juvenile custody with a juvenile case, all of that is most of the procedures are in the family code until it gets to what the crime is. The definition of murder and what a murder is or aggravated robbery is in the penal code, but the process that you're going through is in the family code.
Okay.
So, can I just suppose two things, because it reminds me, you find the same dynamics in the medical field that you find in the legal field when you're dealing with family members. Say you have a family member that's sick, and the family members will come to the hospital and try to tell the doctors and the nurses how to take care of the patient. They're not doctors, but they will try to control that. You know, again, what you were saying about a family member, when they talk to the lawyer, they watch a lot of TV, and they hear, they watch a lot of TV, and they believe what happens on TV acts out in real life.
It's one of the most frustrating things a lawyer has to deal with, is having to talk to family members that are telling you, or I want you to talk to this person, because this person has this information. They don't know about it. They don't know anything, but they will tell you, and you got to spend all this time, and if you're not attentive, that itch is, that witch is stuck up. They don't, but it's like, it's a waste of time because you don't know anything about the system. I try to make people go to court about 10 times and sit there and watch how the process goes. It bothers me that there's so many community activists that are saying, DA Ogg sets bonds. She doesn't set bonds. That's not in her power. The DA's job is in the Texas Constitution. The judges are in the Constitution. The grand juries in the Constitution. And they're in the statutes. Everybody has a role to play, and we need to know what those roles are. The judge controls the court date. The judge controls when it goes to trial. The judge controls the bond and the settings. The DA accepts charges and prosecutes it, but they don't go to court unless the judge says go to court. Like you always hear people say, defendants say, your peers say when y'all were there, my lawyer reset my case. The lawyers don't reset the cases. The judge resets the cases. The judge is coordinator. Now, every day you come to court, you're either supposed to have the discovery or say, my client's ready to go to trial. A lot of times, lawyers know the longer you take, the worse the prosecutor's case gets, because witnesses get old, they get stale, they don't want to come a year or two now. So a lot of lawyers don't mind if it's changed, but most lawyers are not saying, I want to reset. They want to get in and get out, get their money, get in and get out. They don't want to have a case lingering for 4, 5, 6 years. Now, a year is reasonable for a felony case because things develop and change, but that's not normal. And the court can't manage 2,500 cases, and everybody's case can be taken every day. You see what I'm saying? So a judge is not doing that intentionally to be ugly. I mean, 2,500 cases and it's just one judge, so you got to spread it out. So the judge might say, okay, we can deal with, 50 cases today, and if they don't work out or plead, we're going to reset them again because we already have 100 cases set for trial out of 25. So they can't get to 100 cases. You can't try but one case a week.
So one thing that I want to speak to, like the families, but also I just recently saw a job for jailhouse lawyers. There's some national organization, and literally it said, we want jailhouse lawyers, people that was in the jail helping individuals. And if I see it, I'm gonna send it to you. But I saw that like 2 days ago.
I don't want that job.
No, I just I know you don't. The thing that I saw about the families, especially working at the public defender's office and then working in the community for places like Sarah and everything else, and it's across the board, right? When I was helping individuals with workforce development, and the parents end up calling or somebody end up calling and frustrated because that person couldn't get in this class because they didn't have an ID, like they didn't tell them that, right? But that's one thing I realized is that a lot of people that go through the criminal system, it's really their first time. Because I went through the criminal system. When I was dealing with people that was going through the criminal system, I thought that, hey, man, you've been here before. Sometimes they've never been there. So when they get frustrated and asking these questions and trying to figure out what's going on in court, it's the fact that they don't know. But a lot of people don't want to show the ignorance. Not ignorance in a bad thing, but ignorance in saying that, hey, I've never been here. And that's okay that you've never been here. But that's been my experience more so than not. And I
Let me
realized
just say this. I'm a communicating lawyer. And Danny knows he worked for me for at least a year, maybe 2. I communicate with my clients, but they want to hear the same thing over and over and over again. That's another thing is like, what's happening on my case? I mean, if there's something
But they don't have that right because your client is the one that you should be communicating with.
That's what I'm talking about.
Yeah, your client.
No. I mean, I'm saying when Danny worked for me, we went to the jail every Sunday. Or every other Sunday. Did we go like every Sunday, every other Sunday?
No, you went every Sunday.
We went every Sunday to see the same old guys. And guess what? 2 of those guys are still in jail, and that was over 7 years ago.
Are you serious?
Yeah, I haven't checked all of them, but I know Fields, one that was named Fields, he was a tall, dark-skinned guy. He's still in jail. I saw a list of homicides that are coming up next year.
I still got those files.
Yeah, two of those young men I know, I just saw their names on a list of old pending cases.
They're still in the county?
Yeah.
These are capital murder cases.
Yeah, they capital
okay.
murders. Yeah, they capital murders. But they shouldn't still be in the county. That means that their cases hadn't come up for trial yet.
Ooh, that's a long time to be in a county.
In the county.
Jesus.
And I've been here since January 1st of 17.
I think one guy been there for at least 12 years.
Well, I know there used to be, the longest one was a guy that was 10 years a few years ago, and they finally got his case done.
Okay.
But no, it might be 12 now because that was a few years ago. But yes, no, it's... But it was frustrating is that when you do go visit them, like a lot of lawyers don't go visit their clients. I used to go visit the court appointments, non-court appointments. I would pay Danny as my paralegal because they just want to spend time with people. But your lawyer, that's not your lawyer's job.
Exactly.
But they want family, and so I used to, pay Danny as a paralegal to do a social study history, to just try to find something that could mitigate their punishment. And to figure out what their role was. Because a lot of times in these capitals, it's a bunch of co-defendants, but your client might not be the one that was the shooter. So, yeah, because it was one little boy thought he was his daddy. He loved Danny.
Well, the thing about it is I had been there, done that. And so what I try to get most of our clients to look at is don't stress your mother out. A lot of them were stressing their family out. And I would always pose this question. If they let you out right now today, what would be different? If they just told you, you can leave, what are you going to do different? Or would you go back to the same lifestyle? Because if that's the choice, you would only be back in the same situation this time next year.
What was the common answer?
Well, it made them think, because I wasn't really looking, it was rhetorical.
They didn't know how to answer.
I mean, but it would make, it was something to distract them from crying and whining about, this situation not going to change because you hadn't changed. And if you got out, you're still going to be the same person doing the same thing. So this is your moment now to take a step back and look who I was with and how I was living. And it just went bad. It went bad. But if you get out, you want to get back rolling with your homeboys or get it back in the game. You went, because I was asking, were you working? What were you doing? Did you have a job? You know, so I try to find out exactly what the lifestyle was, and they was honest because they knew I wouldn't. Once I shared my story of I said what they said, and I said, you know, I didn't want to drag my mother through making them believe I was innocent for something I knew I was guilty for. So I never told my family when I got arrested, Mama, I ain't do nothing. I ain't do nothing. Give me a lawyer and let them go mortgage their, put their houses up and raise all money thinking, oh, we believe Danny didn't do it. I didn't do that. And I tried to tell them that part, that I didn't call my mom and said I was guilty, but I didn't call her until I was innocent.
Well, Mark is letting us know that that's very interesting. There's 2 minutes. So if y'all want to say some closing statements, I know you wanted to say something, but Damion, why don't you start?
Throughout the year, I'm just thankful, man, that we were able to, reconvene. Like, this is a big part of my life, and y'all saw, like, my frustration sometimes not being able to be a part of this. This is something that I went to school for and graduated, and I really, really enjoy media and having the opportunity to create content, but more so to talk about relevant topics, and then have someone like you with the ability and the stature that you have in this community and really throughout the country allow us this platform. So it means a lot to me to really be able to be a part of this and share this table with y'all, man. So I'm thankful for that, and I look forward to a big and crazy 2024.
All right, Danny, what's your closing statement?
Well, again, we were able to return after a 2-year hiatus, and I'm just glad we had this platform. I don't think about my own growth, but the people in my lives. I watched your daughter grow up.
Thank you.
You know, since I know, you know what I'm saying?
I know it.
And when we saw Morgan, and now she works, she's so independent.
Yeah.
So it's just not been about my journey since I got to Houston in 2008. I think about all the people in my lives and all the people I met. I didn't grow alone. I grew alongside people. I watched Vivian go from a defense attorney to an assistant DA. But just like when LeBron had that science, they used to say, I was a witness to LeBron's great feats.
Exactly.
I'm just so glad that I've been able to watch some of your great achievements in your life and be able to say, I was a witness when you made that pivot from being a defense attorney to assistant DA.
First assistant.
And I was so proud to be able to say, hey, I know her.
It's my people.
They're my people right there.
Yep.
And I brag about you all the time.
And have I changed? I'm still the same.
Right, but this is the 4th largest city, and for my background, and to be connected with someone at that level, when you look at that, I stayed in the criminal justice system, but now I'm out working this close to someone in the criminal justice system.
Yeah.
You just
Well, I
can't
just
make
want to
that
say
up.
that to end it up, that it's been my honor and my pleasure to work with both of you, Danny and Damion. I've never thought I was above you. I've always wanted to just educate you, and I'm proud of both of you for not returning to the criminal justice system. We've had a lot of guests who were fighting that fight to climb out, and some returned. And it takes a lot of internal fortitude because the cards are stacked against you. They're against both of you. And it's just really important for this to be my community service, back to the community, to tell stories of sorrow, mistakes, love, and redemption. I mean, that's just really important to me as a lawyer, and since I chose to be a criminal defense attorney and a prosecutor, I want to tell people's stories. So thank you for this opportunity, and thank you for a great 2023, and we look forward to telling your story in 2024. Good night. Thank you for tuning in again. Tonight we have something